Welcome, everyone. My name is Kerry Abrams, and I'm a professor at the law school, and I wanted to thank all of you so much for coming to our event on After Windsor. I wanted to start by acknowledging the person who is really the inspiration for the event, Charlotte Patterson from the Department of Psychology, who is also the chair of the program in Women, Gender, and Sexuality at UVA. Charlotte contacted me last summer and said, you know, this big case just came down. This is a historic moment for all of us, for students, for staff, for faculty, for Virginians, for Americans. We should do something about this. And we decided to put on an event, both on main grounds and at the law school, to talk about the impact of this historic case on Virginians, on Americans, on the law. And we ended up dividing it into two sections. So I think that this was a little bit accidental. It had to do with when our speakers could be here, really. But it's had some, it's been a happy accident, I think, because the result is we are now 6 months almost from the first half of the event. And a lot has changed in just 6 months. So that's a little bit what we'll be talking about today. Our first event was an event on September 11th on main grounds, in which we talked about the immediate impact of the Windsor decision. And now I think it's been 5 months and 8 days since that first event, and a lot has changed. So I just want to say a few thank yous, introduce our panelists, and then I'm going to say a few words about the Windsor decision and what has changed since then. And then I'll hand it over to our very distinguished panelists. So first, obviously, thank you to Professor Patterson. This would not have happened without you. Also to the program in Women, Gender, and Sexuality, to the UVA LGBTQ Center, to Lambda Legal Alliance, and especially to Hillary and Kyle and James for putting up posters and participating in putting on this reception, and to the Law School Intellectual Life Fund, and Vice Dean George Geis, who's the person that agreed to help sponsor the event. I want to introduce our speakers. To my immediate right is Professor Nancy Polikoff, Professor of Law at American University's Washington College of Law. She is the author of Beyond Straight and Gay Marriage, Valuing All Families Under the Law. And I'm just delighted to have her here. She is one of the people I have admired from afar for years and years, and so this is a real honor for me to be on the same panel with her. She also has a great blog that goes by the same name as her book, which I check frequently. She scours all of the case law for any development on the family rights of LGBT folks, and it's updated frequently, and her comments are really incisive, so you should check that out if this is something that interests you. To her right is Deborah Hellman, our very own FDG Ribble Professor of Law. And as many of you know, she teaches courses here on contracts, constitutional law, bioethics, profiling, equal protection, and some of you are in her class right now. For those of you who aren't, you should make sure to take a class with her before you leave. And she is the author of When is Discrimination Wrong? So before I turn it over to them, I wanted to say a few words about the Windsor decision. So last June, the Supreme Court struck down Section 3 of the Defense of Marriage Act, otherwise known as DOMA, which defined marriage as between a man and a woman for all federal purposes. Now, the immediate impact, one immediate impact was very clear. One immediate impact was that meant that anyone who was married in a state that allowed them to marry was now eligible for federal benefits based on their marriage when they had not been before. The Windsor case itself was about the estate tax. The plaintiff, Edith Windsor, her spouse had died, and when her wife died, she got hit with an enormous estate tax bill, which normally she would not have had because there is no estate tax consequence if it's a spouse who leaves someone an inheritance. But this also affected other federal rights. So the right to sponsor a spouse for immigration benefits, the right to get Social Security survivor benefits or Social Security retirement benefits based on a marriage, and many other federal benefits. However, while the Supreme Court on the one hand struck down DOMA, with the other hand it left another law alone, and that was Proposition 8 from California in the Perry case. They didn't say it was constitutional for California to ban same-sex marriage. They just said that the parties didn't have standing to bring the case. So this put lower courts in an awkward position. On the one hand, we know that DOMA is unconstitutional. On the other hand, we don't know what they would have made of a state marriage ban, like many states still have. So there were two big open legal questions after Windsor, and I'll say a couple words about each. One was, does the state you live in have to recognize your marriage in order to now be eligible for these federal benefits? And the other was, are the state bans unconstitutional as well? So let me start with the first question about the state you live in. So imagine you're a Virginian, married to someone of the same sex, but you married somewhere else because you couldn't get married here. But you come to live in Virginia. After Windsor, are you eligible for all these federal benefits? Clearly, if you lived in Massachusetts, if you got married in Massachusetts and stayed there, then you'd be eligible for them. But what happens if the state you're living in doesn't recognize your marriage? This question was governed by a kind of arcane rule known as the celebration rule. And the Obama administration was in the position of having to decide what rule to apply. Were they going to apply this celebration rule, or they were instead going to apply the domicile rule? So the celebration rule would say, your marriage was valid in Massachusetts. That's where it was celebrated. It's valid everywhere. The federal government will recognize it. The domicile rule would say, you're domiciled in Virginia. Virginia doesn't recognize you as married, so you're not married for federal benefits. And the Obama administration told every agency to figure out which rule should apply and gave a pretty strong nudge, it appears, that the celebration rule might be the better way to go. You can probably guess which one of the first agencies to jump on board with the celebration rule was. The IRS. You can't evade that marriage penalty by moving to Virginia. But several other agencies followed suit. DHS was very quick to say that immigration benefits were going to use the celebration rule and not the domicile rule. So that seems to be close to being resolved fairly quickly. This second question of what happens to the state marriage bans is more complicated. Last fall at our Windsor event part 1, we had no idea what was going to happen. We knew that some lawsuits had been filed. There were 2 in Virginia alone and many others across the country, challenging state constitutional amendments that banned same-sex marriage and challenging state laws that banned same-sex marriage. But we didn't know what would happen. Well, today I did a little research. I was aware that there had been some cases, but I didn't know that there were 61 cases that have come down since Windsor that cite Windsor in striking down some sort of anti-LGBT statute or constitutional amendment. Now, not all of these are state marriage amendments, but there are a lot of cases out there that are relying on Windsor to undo some discriminatory laws. Marriage alone, I might be missing one, but I'm just going to read the ones that I found. New Jersey on September 27th, New Mexico on December 19th, Utah on December 20th, Ohio on December 23rd. Is it starting to sound like dominoes yet? Oklahoma on January 14th, Kentucky on February 12th, and then just in time for Valentine's Day, Virginia on February 13th. So some observations about this. Most of these cases, from my very quick reading of them, are applying rational basis review to strike down marriage bans. That's not that surprising, given that Windsor was not exactly clear about what level of scrutiny it was applying, but it appears to be a low level of scrutiny. So the idea is that these laws are based on animus, and therefore they don't even survive rational basis review. A couple of them have applied intermediate scrutiny instead, but rational basis review seems to be the trend. Another thing that I noticed is not all of these are direct challenges to same-sex marriage bans. There have been some very creative ways of litigating this question. So for example, the Ohio case is about the right to remain married. So the way that the court articulated the right and the way that the plaintiffs brought this case, they said, look, we were married in Maryland and Delaware. We had rights. We came to Ohio. Our spouses died. We now need a death certificate, and you won't give us one because you don't recognize our marriage. And we need that death certificate in order to get life insurance payouts, claim our Social Security survivors benefits, administer the will, transfer the title of cars, all the things that you have to do when a spouse dies. And so it's not a question of whether there's a fundamental right to marry. It's a question of whether the government has taken property without due process of law by taking away a marriage that already existed, which I thought was an unusual but creative way of addressing this. Of course, that means that the marriage issue is still live in Ohio because now there's this ruling, but then still not a affirmative right. So I think it's too early to tell what's going to happen in the next 6 months, but a few thoughts on that. One is that, so same-sex marriage is now the law of 17 states plus the District of Columbia. 6 were by court decision, 8 by state legislature, 3 by popular vote. 5 of those 8 that were passed through the state legislature have happened since Windsor. Now, I don't think that's necessarily causal. I don't think it's necessarily that the state said, oh, the Supreme Court has ruled, now we have to pass, we have to get rid of our same-sex marriage ban and allow it, although I'm sure that the nudge that Windsor gave didn't hurt. But what we may be seeing is the Supreme Court correctly understanding the tenor of the country and ruling in a way that was likely already going to happen at the state legislature level. So you see the judiciary and the legislatures kind of propelling each other forward, and it's hard to know what is causing what. And I think there are a couple open questions that I'm hoping our panelists will take up. So the first is this question of federalism. The Windsor decision was about a federal law. It wasn't about one of these state laws. A lot of the states seem to be interpreting it to mean that their state laws are also unconstitutional. So what's the correct balance here between state control over marriage and the federal constitution? And the second is a question about what marriage equality should mean. So there's been so much focus on getting access to marriage for a discriminated against group of people. And there's been less focus, although Professor Polikoff is a big exception here, on the fact that marriage creates inequality itself. So we tie all these benefits, like access to health care, a secure retirement, even the rights to legal parentage to one's children, to the institution of marriage. And so what we may end up with here is not just more equality for entering into marriage, but maybe even less equality between married and unmarried, as marriage once again becomes the only approved of legal institution for adult intimate relationships. So I hope we will get to talk about whether that is a good development or not. So those are my opening thoughts, and now I'm going to turn it over to Professor Hellman.
Thank you, Kerry. And I have my tissues up here because I have a cold, so please excuse me if I have to blow my nose in the middle of it. So that was a fabulous introduction, and I want to take up the question about the role of federalism. And I want to present this as first introducing on what grounds did Windsor reach the opinion, the decision that it reached, and what role did federalism play in that, and then what does that suggest for the constitutionality of state bans on marriage. So when we look at Windsor, you'll see both in the debates among some of the dissenting opinions, as well as in the way that Windsor is being treated in the lower courts, you see a debate about the role that federalism played in that opinion. That is, you see, say, the Chief Justice arguing that Justice Kennedy's opinion rests in part on federalism grounds, and you see Justice Scalia challenging that view. So what do I mean by federalism grounds? Well, traditionally, states have had the right to define marriage as they would like. And in Windsor, the opinion reads, where it begins by talking about the importance of states being able to define marriage as they would like. And talk, just to give a few, well, we'll get to that in a second. So they talk about the ability to define marriage as they would like, but it also rests on other grounds. That is that restricting marriage to opposite-sex couples, says Justice Kennedy, demeans gays and lesbians and their unions. And the question is, what's the role that the federalism part of the rationale plays in the court's decision? Well, before I get into more detail, you might wonder, why does it matter? Why do we care what role federalism plays? Well, suppose Windsor rests on both prongs, both on the federalism ground that states get to decide for themselves what marriage is, and the feds shouldn't intervene, or at least they only should do so for a very good reason. And it also rests on the prong that DOMA demeans gays and lesbians. Well, in the case of DOMA, those two prongs point in the same direction, right? We have a federal law that's intruding on state prerogatives, and we have a law that's according to the court in Windsor, demeaning gays and lesbians. So those two rationales, those two prongs, are pointing both in the direction of overruling in the case of Windsor. But what about state laws? If we have state laws defining marriage, then those two grounds are going to point in opposite directions, right? Not only do you not have the federal government intruding on traditional state prerogatives, but indeed you have the state exercising their traditional state prerogatives to define marriage. And while there might be a problem with a state law that possibly demeans gays and lesbians, we'd have to balance that against the state right to define marriage as they'd see fit. So the question matters because in the Windsor case, those two rationales point in the same direction. If we have a state law that we're considering, those two rationales are going to point in the opposite direction. So what would happen then in the case of a state law? And how important will that federalism rationale be? In what follows, I want to argue that neither the view that federalism plays an important role and therefore that the state, it's absolutely unclear what the state courts should do, neither that view nor the view that federalism plays no role and therefore we just apply the kind of other rationale, the rationale that the law demeans gays and lesbians, that neither of those is quite right. So you have some people saying federalism is an important piece and therefore the state laws are really quite different, and you have people saying, oh, federalism, Justice Scalia says, from this opinion we can automatically conclude that the state laws should fall. I don't think that's quite right either. So I want to argue for what I think of as a kind of a nuanced in-between position, the one that I think is closer to Scalia's, I don't think that federalism is an independent rationale for the decision. Rather, I argue that Justice Kennedy concludes that DOMA demeans gays and lesbians because the federal law intrudes on an area traditionally left to the states. So here's what I mean by that. It's a kind of nuanced position about why should we conclude that the federal law demeans gays and lesbians. It demeans gays and lesbians in part because we know that it's expressing a kind of negative message towards gays and lesbians, in part because it's intruding on an area that's traditionally left for the states. Now that may sound like an odd conclusion and one that doesn't make a lot of sense, so let me try to lay it out for you a little more clearly. All right, so first, let's look a little more closely at the grounding for Windsor. As I said, in part it's based on the idea that DOMA demeans gays and lesbians. So let me give you a passage from from Windsor. The court says in Windsor that DOMA, tells those couples, gay and lesbian couples, and all the world that their otherwise valid marriages are unworthy of federal recognition. This places same-sex couples in the unstable position of being in a second-tier marriage. The differentiation demeans the couple, whose moral and sexual choices the Constitution protects, and then the court cites to Lawrence, and whose relationship the state has sought to dignify. And it humiliates tens of thousands of children now being raised by same-sex couples. Let me take a little moment to step aside for a second and note something about this rationale. So this is sort of the heart of the Windsor opinion, and I want to point out two things about it. One is, I would call this equal protection in the key of respect. If you listen to the language, Justice Kennedy uses the word dignity at least 10 times, or dignity or indignity, some variation of that, at least 10 times in the opinion, and that's not even counting all the other language that's kind of in the space of dignity. Ideas like humiliation or its opposite, respect. What makes this a violation of the Constitution for the court is that gays and lesbians are not being treated with equal respect as other citizens. So let me give you a few other passages that have that equal protection in the key of respect theme. So the court says, the history of DOMA's enactment and its own text demonstrate that interference with the equal dignity of same-sex marriages. The key word dignity there. Next, the act's demonstrated purpose is to ensure that if any state decides to recognize same-sex marriages, those unions will be treated as second-class marriages for purpose of federal law. So what bothers the court is that it's a failure to accord gays and lesbians the respect due to them as persons, a failure to recognize them as equals, something along that dimension. So the first thing to note about this part of the rationale is this language of respect. What makes it an equal protection violation is it's a failure to accord respect as an equal person. The second thing to note about it is it seems to avoid all the kind of traditional apparatus that we learn in constitutional law. That is, where's the tiers of scrutiny part? It's not just what Professor Abrams said that, it's applying rational basis review, and so it's maybe resting on animus. I would say it doesn't even bother with the tiers of scrutiny. Tiers, schmears, we don't really care, right? The second thing is, it's not really clear whether it's an equal protection holding or a due process holding. Court says that it violates both equal protection and due process. Same kind of thing we saw in Lawrence. Lawrence was a due process case, but the language was so equal protection-y, right? So it's a fusion of equal protection and due process and a kind of blowing away of the tiers of scrutiny. So two interesting things about the rationale on that part of it. One is the jettisoning of all you had to learn in constitutional law about tiers of scrutiny and even about whether we worry about whether it's due process or equal protection. Although to me, I hear it more as equal protection. To me, the idea of treating people with respect and dignity, to me, sounds equal protection-y. But the court isn't clear. And the second is the incredible emphasis on respect. Okay, so that's one part of it, but the other part of it is the federalism. And the federalism part actually precedes the part that I just read you, and here are a couple passages from that part. The recognition of civil marriage is central to state domestic relations law applicable to its residents and citizens. And then following on that, consistent with this allocation of authority, the federal government through our history has deferred to state law policy decisions with respect to domestic relations. So it sounds as if the opinion rests on federalism, respect for state prerogatives to define marriage, and the federal obligation to respect those powers. But now I want to look a little bit more closely on the role that federalism plays in the opinion. As I said, it precedes the part about dignity and respect and all that. So while the majority does spend in Windsor does spend considerable time discussing the fact that federal intrusions into definitions of marriage are unusual, etc., this discussion is not made to support the claim that states have a right to define marriage. Rather, Kennedy argues, and this is a quote, DOMA's unusual deviation from the usual tradition of recognizing and accepting state definitions of marriage is strong evidence of a law having the purpose and effect of disapproval of same-sex couples. So what he is saying here is that DOMA expresses that gays and lesbians are second-class citizens. It's got this affront to dignity part of it. How do we know that? How do we know that it's an affront to their dignity? Because the federal government is going out of its way to legislate in places it doesn't normally legislate in order to say that gays and lesbians can't marry. It's not that what makes it a violation of the Constitution is that the federal government is intruding into state powers. It's rather that the federal government is violating the equal dignity of gays and lesbians. How do we know this law is doing that? Because the federal government is digging into a place it doesn't ordinarily belong. In making this claim, the court cites to Romer, and it makes a point that essentially says, do you remember Romer, the amendment to the Colorado Constitution? And when the court cites to Romer, it says, look, that law was kind of weird and unusual too, and it was. Amendment 2 to the Colorado Constitution was very odd in its format. And the court says, that law was weird, and that was a signal that something was amiss. And this law is weird too. So what the federalism part is doing is it's acting as a signal for this is weird, right? The federal government doesn't usually muck around in marriage definitions. So when it does that, that's a sign that something troubling or something kooky is going on. And the cite to Romer shows us that part. So what should we take from that? Well, that's a highly contextually grounded analysis of why DOMA is an affront to the equal dignity to gays and lesbians. The court's not saying that any restriction of marriage to opposite-sex couples is always, in all contexts, something that is an affront to the equal dignity of gays and lesbians. It's saying in this context where the federal government is going out of its way to go into something that's normally the state's, bailiwick, that then sends the message that gays and lesbians are not full citizens. When we think of it that way, it's harder to say what should follow from that for the states. So what are the implications for the state laws? So for one thing, I don't think we have a case where the state laws get the benefit of the federalism concern. The federalism rationale in DOMA wasn't doing any work in the sense of asserting an affirmative right of states to define marriage for themselves. And really, in a way that I think would have been a weak argument if that's what DOMA had said. Obviously, when those states normally have the right to define marriage, when they do it in a way that violates constitutional guarantees, equal protection guarantees, then we strike that down and we can cite to Loving for that proposition. So it can't be that that would be some sort of safe harbor, the federalism idea. But if the federalism point is working as in this highly contextualized idea that it's saying, given that the federal government is going out of its way to get into the state's business, and that's what makes it especially an affront to the equal dignity of gays and lesbians, we're going to be missing that piece when we have the state laws. And because now we don't have the states aren't getting into anybody else's business. They're doing what they always do, which is to define marriage. And that's why I say that we can't straightforwardly just apply Windsor and say that the state law should fall. That being said, I think it's a natural extension of the reasons that the court offers to hold that that DOMA violates equal protection / due process, whatever you want to say there, but violates the Constitution. That is, it is an extent, it follows naturally, but I think more legal work will have to be done in order to make the claim that that these also are an affront to dignity in the way that the court wants to say. So it's not a simple application, as Scalia suggests, but it follows as a natural extension, I would say. And when we look at what the states are beginning to do, Kerry, Professor Abrams talked about a few of the state decisions, and actually I think we see a little bit of a variation. The Virginia opinion, which I read a few of them also, not just quickly today. The Virginia opinion I read as very due process, right to marry kind of grounds. The Kentucky opinion, I think, is sticking closer to Justice Kennedy's emphasis on demeaning. You see that language in the Kentucky opinion. But none of them are going yet further to make the argument that these state laws pass that extra hurdle of being clearly demeaning, even though they don't have this going into somebody else's business idea. I want to say one last thing, which is, what do we expect from the court? So it's always bad to predict the court because one is always wrong, but I'm going to do it anyway. So I agree that it seems like there's an inevitable march. I expect the Supreme Court to strike down state bans on same-sex marriage. I think the court's moving gradually, though. If you think about what the court did in Windsor, it was very careful in that respect. It said this very careful statement that when the federal government reaches out of its usual area and into an area of state concern to specifically exclude some straight granted marriages from federal recognition. This demeans the dignity of same-sex couples. Then, as Professor Abrams said, it waited on Perry, dismissed it on standing grounds. The Ninth Circuit in Perry had also done something extremely careful, as Windsor did. It said that the amendment in California, Proposition 8, violated the Constitution on equal protection grounds because of the unique history of what happened in California, that first there were some marriages granted and then there was this amendment that took that away. So it said that it also used very much this kind of demeaning language. It demeaned the equal dignity of gays and lesbians, but not because any ban on same-sex marriage would, but because of the particular history of the California trajectory. That's also a very careful, very narrow reading. Right now, I see the district courts as being more bold. That is, they're just saying there's a fundamental right to marry or it's a violation of equal protection. And I think we'll get there, but I think it will be careful, small steps till we get there. And I'll stop there.
Thank you, Charlotte. Thank you, Kerry, for inviting me to come here, and thanks to all of you. I know that some of you are here because you're required to be, but some of you are here because you're interested, and so I appreciate that level of interest. Over half a century ago, 1961 to be exact, a 23-year-old Chicano woman, Jeanette Hatsopoulos, and a 19-year-old African-American woman, Donna Levy, began living together in a lesbian relationship in Denver, Colorado. They lived together 13 years. Jeanette was essentially a homemaker. Donna supported them both. Jeanette had a pattern of self-destructive behavior, drugs, alcohol. In 1966, the couple moved to California. They both wanted to raise a child. In fact, in 1988, they contacted an adoption agency, but nothing came of it. Donna couldn't have children, and so Jeanette announced she would have a baby for Donna. And while the couple was on vacation, 2 months before Stonewall, Jeanette met a visiting student at a party, had sexual intercourse with him, and became pregnant. It appears they never saw each other again. Candace Hatsopoulos was born on January 21st, 1970. Jeanette cared for her while Donna worked. Donna cared for her in the evenings and on her 2 days off a week. The family returned to Denver in 1972. Although Donna and Jeanette by that time were no longer lovers, they continued living together for about 2 more years and raised Candace together. Jeanette's behavior deteriorated. She attempted suicide. Donna found her psychiatric treatment, took care of her, took care of Candace, all while supporting the family in her job as a bus driver. In 1974, Donna had more than she could take of it and moved out, but for 2 more years, she had Candace 2 days a week when she wasn't working and spoke to and saw her every single day. On July 5th, 1976, Jeanette committed suicide. Candace was 6 years old. We know this story because Donna's sister challenged Jeanette for the right to raise Candace. And after several months of separation and a temporary order for Donna's sister, the court ultimately did place Candace with Jeanette. Just before Candace was born, Nancy Springer and Michelle Graham, 2 white women in their early 20s, began their life together in California. Michelle wanted to raise children. Nancy ultimately agreed. They used donor insemination, and Nancy gave birth to 2 children, Kate in 1980 and Seth in 1984. The last name of both children was Newlin, a name from Michelle's family. And using her initials only, Michelle's name was actually on the father line on the birth certificates. When the couple later split up, Kate stayed with Michelle, Seth stayed with Nancy, with the children having a lot of time together during visitation. Both children called both women mom. But 3 years later, after a disagreement, Nancy filed a petition under the state's Uniform Parentage Act, and the court declared her the sole parent of the children because she was their natural mother. Now, these stories are decades old. Candace Hatsopoulos turns 44 this year. But I want to use these stories to think about how we got from there to here and about the role that lawyers played, our brilliance and our blind spots, and a bit about what the future holds, especially a future with same-sex marriage. So I'm going to get back to Donna and Jeanette, but for now, I'll look at Michelle, a non-bio mom whose situation is quite familiar. Nancy and Michelle were the beginning of the post-Stonewall, post-second wave feminism generation, the first generation of lesbian couples to use donor insemination to bear children and raise them as two moms. There were a handful of us lawyers back then who watched this phenomenon with some alarm, seeing the legal obstacles that existed. The law thought the children had one mother, and we knew they had two. And so were born the theories in support of second parent adoption. I'll call this a moment of brilliance. It was unlikely that a legislature would actively support this new family form, so we turned to the courts and created the arguments, becoming scholars of statutory interpretation. And we made a difference. We made it possible for the law to match the family form that the couples were creating. I don't remember if I ever thought second parent adoption was the solution, but if I did, it was short-lived. It worked for the families who used it, and it still does. But it requires time, money, lawyers, comfort with the court scrutiny of one family, and many people just don't do it. So in recent years, we lawyers have been working on solutions that create parentage without the need for second parent adoption. And so here's where I will confess a blind spot by talking to you again about Nancy and Michelle. The smartest LGBT legal minds in the country worked on Michelle's case in the late 1980s and early 1990s. We agreed that she was not the children's natural or adoptive mother under the California Uniform Parentage Act. But we argued numerous theories of estoppel, de facto parentage, psychological parentage, all to no avail. This is what we missed. The original UPA, adopted in California, created a presumption of parentage for a man who received a child into his home and openly held the child out as his natural child. Although natural child was undefined, the common assumption was that it meant biological child, and that's certainly what Blackstone would have said about it. Then came Thomas and Kimberly, who met when Kimberly was pregnant. They never married. Both decided they wanted Thomas to be the child's father, and when Nicholas was born in 1995, Thomas's name was placed on the birth certificate. He functioned completely as Nicholas's father. So several years later, there was a dependency proceeding involving Nicholas, and the court said he couldn't remain with his mother because of her instability, drug use, homelessness, lack of employment, and violence. Thomas wanted to keep raising Nicholas, but the lower court ruled that Thomas's admission that he was not Nicholas's biological father rebutted the parentage presumption. In a unanimous decision, the California Supreme Court reversed. It cited the statutory language that a parentage presumption may, not shall, be rebutted. And after some additional statutory analysis, the court established that natural did not, in fact, require a biological connection. Now, California had another provision from the 1973 UPA stating that the rules for determining paternity applied also to determinations of maternity insofar as practicable. So in the case of In re Karen C., a woman, Letitia, raised a child, Karen, from birth at the request of Karen's mother, but never adopted her, although Letitia had told Karen that she was adopted. When Karen was 10 years old, she came into the dependency system, and she and Karen joined in a motion for a determination that Letitia was Karen's mother, a finding that would make sure that she would get services so that she could continue to raise Karen. They argued that Letitia received Karen into her home and held Karen out as her natural child, and that the provisions for a father-child determination applied to maternity determinations, and that therefore she was a presumptive parent. And although she lost in the trial court, after Nicholas H., the appeals court sent it back for a new look. A year later, a California appeals court squarely applied the father-child holding out presumption to a determination of maternity. In Re Salvador M., a half-sister, Monica, raised her half-brother, Salvador. When Salvador was born, Monica had a baby of her own, and so she actually breastfed Salvador when their common mother was unable to. When Salvador was 3, his mother died in a car accident, and Monica continued to raise him and raised him as her son, along with what were then 2 children. All 3 of those children came into California's dependency system, and Monica filed a petition to be determined Salvador's mother. She argued that the holding out provision of the California UPA, coupled with the provision for establishing maternity on the same basis as paternity, made her Salvador's presumptive parent. The court agreed. And then she cited Nicholas H. for the proposition that the fact that she wasn't the genetic parent didn't automatically rebut the presumption. The court agreed. And so, with these 3 cases as precedent, in 2005, the California Supreme Court in Alyssa B. versus Superior Court extended the presumption of parentage with no second parent adoption to a lesbian who had received 2 children born to her female partner into her home and held the children out as her natural children. More than 15 years after the California courts began considering and then rejected Michelle's claim that she was the parent of the 2 children she'd raised with her former partner, it turned out that the theory supporting her parentage had been the entire time hiding in plain sight. The statutes hadn't changed, but in 1991, it had been undisputed by even the most creative and determined advocates for LGBT families that Michelle was not the natural mother of her children. Why didn't we see this argument in the 1980s? It appears that we needed the insights and doctrinal developments from the lives of non-traditional heterosexual families. We needed the cases that would emerge from the 5-fold increase in the number of cohabiting unmarried couples and the doubling of births to unmarried women. We now have other states that follow this rule. We also have other parentage reform that has obviated the need to do second parent adoption. Some of those, though, only apply to children born of assisted conception, and Donna and Jeanette remind us that that's not enough. We also can't depend on marriage, and so now I turn to the designated subject of the panel, the changing marriage laws in the U.S. Advocacy for same-sex marriage often discusses the children we raise. Justice Kennedy thought that the refusal of the federal government to recognize same-sex marriages humiliated the children of those marriages. State and federal court judges striking down marriage bans often invoke the benefits of marriage for children. But it isn't actually marriage that creates most of those benefits. It is parentage. When both parents are legally recognized through second parent adoption or through operation of parentage statutes, children reap the benefits of having 2 parents. I fear that most people believe that marriage also creates two legal parents. And so I'm going to spend the rest of my time today illustrating why that assumption is problematic. State statutes create legal fathers through a series of presumptions, and I've told you already about one. That only exists in some states. In every state, married men become the legal fathers of their children because a statute extends to them a presumption of parentage. I think advocates for same-sex marriage assume this presumption will extend to the wife of a woman who bears a child, but I'm not so sure. And I have two cases to support my skepticism. These are two cases which, if you read about them, they count as wins for lesbian mothers and their children. And that's why I think people aren't looking at the losses inside the wins. So in Shinovich versus Kemp from Oregon, a non-biological mother filed for custodial rights to a child she had raised with her former partner, the biological mother. The child was conceived through donor insemination. She couldn't claim statutory parentage, so she argued that the gendered parentage statutes were unconstitutional based on sex and marital status. And she won. But she won because sexual orientation is a suspect classification under the Oregon Constitution, and the court found the statutes unconstitutional because of that. But Shinovich argued, that was the donor insemination statute. Shinovich also argued that the statute presuming a husband's paternity was unconstitutional because it didn't apply to her, a female same-sex partner who couldn't marry her partner. And as to this argument, the court held that the marital presumption was a presumption of biological paternity, that even if it encompassed a female unmarried partner, it wouldn't apply to her because she wasn't the biological parent. The court said for the presumption of parentage to apply, it must be at least possible that the person is the biological parent of the child. Now let's look at Gartner versus Illinois Department of Public Health. After the Iowa Supreme Court found the state's ban on same-sex marriage unconstitutional, Melissa and Heather Gartner married. Heather got pregnant through donor insemination, and when the child was born, the state refused to put Melissa's name on the birth certificate. They said she had to adopt the child, and then they'd be happy to do that. The state argued she didn't get the presumption of parentage because she wasn't the biological parent. The trial court ruled that the presumption statute applied to her, but the Iowa Supreme Court reversed on that point. So the statute said if a mother is married when the child is born, the husband shall be entered on the birth certificate as the father unless a court says otherwise. And in construing the statute, the court said we're bound by legislative intent. Yes, oftentimes the words of one gender include the words of the other, but not when the statute uses both a masculine and a feminine term. So this can't be applied in a gender-neutral way, or it would, quote, destroy the legislator's intent to unambiguously differentiate the roles assigned to the sexes. Only a male can be a husband or father. Only a female can be a wife or a mother. Now, the court that had struck down the marriage ban in Varnum v. Bryan had done it on state constitutional grounds. And because of that state constitutional ruling, the court held that statute unconstitutional. But here's the problem. In the states that have allowed same-sex couples to marry without a constitutionally based mandate from the courts, in states that don't have heightened scrutiny for sexual orientation discrimination, there is a reason for grave concern that courts will find that marriage doesn't create a presumption for a female spouse. Now let's imagine federal courts imposing marriage on hostile states. We can expect those states to go no farther than they have to. and there is every reason to believe that state courts will rule that the marital presumption cannot apply to a clearly non-biological parent. Without supportive state constitutional doctrine, that will be the final word. And I'd also add that even in states with the presumption, biology is often a basis for rebutting it. If biology can rebut the presumption for a husband with a DNA test, it can rebut it for a female spouse. I want to end today going back to Candace Hatsopoulos, conceived through sexual intercourse. It's a mistake to think that her family is an aberration or something of the past. Every year there's more and more court rulings where, even though it's not the legal issue, the underlying facts show that that lesbian has conceived a child through sex with a man. It's cheap, it's easy, it's reliable, and it's culturally comfortable. According to Williams Institute demographer Gary Gates, 13% of women who identify as lesbian have had sex with a man in the last 5 years. 2% have had sex in the last year. He estimates 1.36 million lesbians. That's over 27,000 lesbians who slept with a man in the last 12 months. If you add in the over 2 million bisexual women, 89% of whom have had sex with a man in the last month, that's 2.3 million women. So census data showed that 2% of women in same-sex couples reported giving birth to a child in the late 2000s. With over 330,000 same-sex couples in the 2010 census, we're looking at 6,600 children born a year to lesbian couples. Some of them are the result of assisted conception, but the data suggests that many of these children were conceived intentionally or unintentionally, with or without the same-sex partner's consent, through sex with a man. How are we to think about parentage after Windsor, after marriage equality? The lessons I've learned are that we have to think about it the same way we think about it without marriage equality. For all the conflation of parentage and marriage, the law of marriage is not a good fit for protecting parentage in the families formed by same-sex couples. And it sure isn't a good fit for protecting the parentage of children raised in multi-parent families. For trying to go down the route of marriage as a way of protecting parentage, I fear that makes marriage an example of a blind spot of today. 25 years ago, our blind spot was assuming that natural had to mean biological. Today, it may be assuming that the marital presumption does not mean biological. And if the answer lies in the holding out a presumption from Alyssa B., it's worth remembering what made that case possible. It wasn't married heterosexuals. It was an unmarried man and woman, an unmarried woman who wanted her child to be raised by another unmarried woman friend, and an unmarried woman who raised her half-brother as her son. The sooner that we see parentage as a clearly distinct body of law unhooked from marriage, the sooner we'll find the tools to protect the Candace Hatsopoulos and all of the other children raised by same-sex couples today. Thank you.